This is Aaron Crawford, and I'm here with Viet Dinh, who was the Assistant Attorney General. And could you just tell us a little bit about your background and how you became involved with the Bush administration?
I was a professor at Georgetown University Law Center. I was tenured there teaching constitutional law. I was not actively campaign, although I was clearly a supporter of the president. I think I was part of a group of small lawyers who were surrogates for the campaign during the election, and especially during the Florida recount. And I think that's how I became known to the transition team.
Okay. Now, at what point did you actually join the administration? When were you offered a position with the Justice Department?
My first time I stepped foot into the Justice Department was in order to interview with Attorney General Ashcroft for the job, who after the interview asked me to meet with the White House, and then I went through a nomination process in February of 2001, and I was confirmed in May of 2001.
Okay, and what exactly does an Assistant Attorney General do? Could you explain a little bit?
There are a number of Assistant Attorney Generals. The hierarchy of the department is the Attorney General with his Deputy Attorney General and a number of Assistant Attorney Generals. The Associate Attorney General also helps the Deputy in managing the civil side of the department's mandate. But there are a number of Assistant Attorney Generals responsible for different divisions or groups of lawyers within the department. I was in charge of an office called Office of Legal Policy, which was started in 1980 by Act of Congress in order to assist the Attorney General and the department in establishing the legal policy and help to vet judges. That office name was changed to Office of Policy Development in 1992, and then when I took office, the Attorney General and the President changed the office back to Office of Legal Policy to reflect the original goal of the office.
So the Office of Legal Policy deals really with judicial issues, and particularly the issue of judges.
Among other things, our mandate was to handle the issues of high priority to the administration and the department, and so we developed and prioritized and implement the legal policy of high priority to the department and the administration. Among the highest priority within our mandate was the selection and confirmation of judges.
Okay. Well, let me ask you, with the Bush administration coming in 2001, where exactly did judicial nominations rate for the new administration in importance? And I ask because we hear a lot of people say that with the Clinton administration, they had not been as important. But it seems to be a change with the Bush administration. How did it rate with them?
I do not know how it compares with other administration. I do know that judges was of the highest priority for our administration. That was evident both in the president's statement of priorities, his actions in taking office and continuing in his throughout his term, and the dedication that he personally put to the process. It was a record pace of nominations that we engaged in the first 2 years of the administration. It was about 10 times the historical average because the president perceived correctly that the judiciary was in a significant crisis of personnel. There were well over 100 vacancies when the president took office, and that meant that the federal judiciary was operating at close to 20% shortage of manpower. So he made a priority to alleviate that work shortage, and in doing so, making it very clear that the appointment of qualified men and women of integrity and judicial competence is a integral, if not an important, if not the most important legacy they would leave for his presidency.
Okay. Now, you talk about this record pace of nominations. And the first group, they were nominated in May of 2001. And it was a really sort of a high-profile rollout of the nominees. Mm-hmm. Could you explain a little bit how that initial crop, how they were selected, and kind of maybe give us an idea of what the process was for
Right.
selecting a nominee?
I can answer the second half of that question, not the first half, because I did not take office until May of 2003. And while I was participating in the confirmation process, we are religiously prohibited from engaging in any activities that may be considered to be office exercising prerogatives of office, because that would endanger our nomination and take away the Senate's role in advising consent. I do know generally that that first group of May nominees are the ones that the president obviously placed the highest priorities on in terms of the courts for whom for which they were selected, the caliber of the men and women that were nominated, and the priority the president made in their selection, and the very clear and strong statement in their nomination and call for their confirmation. It is not to denigrate other nominees, but I think it is correct to say that that group of 10 were among our best nominees and our highest priority nominees for the highest priority circuits that was nominated.
So these nominees were made right about the time you actually came into office.
Exactly.
So the next step is looking at the confirmation process. Explain a little bit about your initial encounter with the confirmation process once you came to office, and for instance, what you expected, and exactly the reality of those.
The expectation and realities were a little bit different because of a singular moment in time. If you recall, after the 2000 election, the Senate was quite evenly divided, and with the Republicans still in control of the Senate. As part of that control also meant that the Republican had control of the Judiciary Committee and the agenda, and so therefore could control the pace and the process for confirming the president's judges. The day that the Senate voted to confirm me to office was also the day that Senator Jeffords of Vermont had switched his party affiliation, whereby he would caucus with the Democratic Party, and so that meant that control of the Senate flipped to the Democratic Party, and therefore the Senate Judiciary Committee would also be under the direction of Senator Leahy as chairman rather than Senator Hatch as chairman. That created obviously a system of division between nomination and confirmation, and so there was a significant sea change on not coincidentally on the day of my taking office.
So could you maybe walk us through what your responsibilities were, maybe in the confirmation process, or did you have any, or how exactly does a confirmation work?
Right. So the Judicial Selection Committee, which is comprised both White House and Department of Justice personnel, is responsible to the president for recommending nominees for his approval for nomination. And once a nomination is made, the Judicial Selection Committee is also responsible for the confirmation of those nominees. The rough division of authority, even though we work very collaboratively in both houses of the process, is that the White House Counsel and the White House Group generally takes the primary responsibility with nomination, with the Department of Justice playing a supporting role in vetting and clearing the individuals, while the Department of Justice would take the primary role in dealing with the Senate in confirming the nominees, with the White House obviously providing the direction and decision making in that process. And so once the nomination is sent to the Senate, we concurrently send that nomination packet to the ABA, whom the Senator Leahy has said was an integral part of his decision-making process, for the ABA to vet the candidate and give him a qualified or well-qualified rating. And then we would work with the Senate Judiciary Committee staff and members in order to review the candidate's qualifications, review the confidential FBI files with the staff and senators, and schedule that candidate for a hearing. Prior to the hearing, we would walk the candidates through a fairly comprehensive preparation process, including both, a history of the advise and consent rule of the Senate, what they're likely to expect during the hearing, and any advanced questions or concerns that the senators may have given us, so that the candidate can answer them intelligently and thoughtfully. And we guide them through this process. We also work with the Office of Legislative Affairs of the Department of Justice in order to walk the candidates through to meet all the various members of the committee and their staff, so that they would get a sense of the person who will be exercising this power of advice and consent. And that's a very informal, very critical part of the process, because through that personal exchange is when the candidate can get to a sense as to what the senator is concerned about, or if there are any questions about his or her record, and the senator can get a good sense of the candidate as a person. And then at the hearing, it's then all up to the candidates in order to answer the questions. And then after the hearing, there is a period for questions for the formal record, and we help the candidates with answering those questions and getting them back to the Senate. And if all goes well, about 2 to 4 weeks after the hearing, they get cleared out of committee, and then 2 to 4 weeks after that, they get a full vote on the Senate and get confirmed to the courts to which they were nominated.
Well, you're kind of telling us the process, and there's a lot of steps there. And knowing that first batch of nominees were really well qualified,
Mm-hmm.
the Senate objected to several and refused to move.
Mm-hmm.
Could you kind of give us your thoughts on that and what your reaction was? Did you expect that kind of opposition to some of these really well qualified?
I expected some opposition. Frankly, it came at different people for different reasons that were unexpected. I think that the resolution of those objections came as differently as expected. I think that Miguel Estrada, for example, was a surprise for everybody, because there is no person who is more well qualified on paper or in practice than Miguel Estrada. He's one of the most accomplished lawyers in the city and in this country. He came here as a refugee from Guatemala and has made extraordinary strides both in his personal development and his acculturation to this country. And by all lights, he is a well qualified and well liked individual. I think he certainly was extraordinarily well qualified to serve in the D.C. Circuit. And I think that a whole lot of people were objecting to him, not because he would serve as a good D.C. Circuit judge, but only because they thought that he was on his way to become a Supreme Court justice. Because the dynamics of the Supreme Court selection process was that there was some significant calls for Hispanic judge to be appointed to the Supreme Court, and everybody was playing the chess game 2 or 3 moves ahead and guessing as to who may be qualified to do that. And I think the outside interest groups, unfairly in my view, targeted Miguel Estrada as a potential Supreme Court nominee, and therefore wanted to cut him off at the pass to the D.C. Circuit. I think that was one of the greatest tragedies of that process, not only as a personal matter for Miguel, which is obvious, but also as an institutional matter for the confirmation of the D.C. Circuit, and certainly for the process in which people were using nominees and judging them not on the merits of their own qualifications, but really as pawns in a larger political or geopolitical game regarding Supreme Court politics. That was very, very unfortunate. I think Mike McConnell was controversial, and expectedly controversial, because he is a very clear-spoken and well-spoken academic. He's written a lot with a very long paper trail. He is a conservative scholar of faith. And in the modern day politics, that's always somewhat circumspect coming from the academy. And he had made some fairly clear statements in writing regarding the legacy of Roe v. Wade, which was then as now a very strong flashpoint issue for the outside interest groups. And so that controversy was expected. But we also expected what happened, which was that all of his friends and colleagues in the academy know Michael to be a tremendously fair-minded and tremendously thoughtful person. He should not be judged on statements taken out of isolation, but all in the grand scheme of things, the entire jurisprudential framework that he brings to the bench. And that's why a lot of wonderful people, including then Dean Kagan of Harvard, who spoke out in favor of his nomination, and he was confirmed. And so some of the controversy were expected and properly resolved. Some of the controversy, I think, was unexpected and in many ways unfair.
So do you see this initial group, sort of the opposition, as sort of maybe a turning point in the process of selecting people for the courts? For instance, I mean, when was the first time you became aware that a filibuster may be used in one of these lower court nominees?
We had, when folks like Priscilla Owen and John Pickering were not voted out of committee, that was a fairly strong signal, But when people who make it out of committee and get filibustered like Miguel Estrada, I think, it starts becoming getting out of the norm. I think that the escalation, if you will, is just a response to the fear that's out there with the outside interest groups regarding the qualifications of these nominees. Not because they're not qualified, mind you. I think that it was because the fear was that these folks were extremely well qualified, but were not sufficiently of the political stripe that the groups would favor, and so the opposition became fairly strident very quickly. Some of it is a response to our own priorities. The rollout of the Group of 10 was a very significant political event, and deliberately so, because the president wanted to make clear that the judges were a high priority, and so the putting out a group of 10 people who are supremely qualified with the imprimatur of a rose garden ceremony at the start of administration is a fairly significant gesture regarding the priorities of this administration. And politics being what they are, the people would like to take, those in opposition would like to defeat the priorities of the president. And so that's a normal give and take of the process.
But you do read a lot that this is a point where these lower court nominees do become really politicized. Mm-hmm. And for instance, Democrats criticize the White House for secrecy and for not really consulting them. But there's a little back and forth there. So can you kind of explain whether, was this politicization, was it new, and why exactly did President Bush make this not just a priority then, but he continued to make it a priority, particularly in the first 2 years? And I'm thinking of the 2002 elections, where he actually campaigned on the sort of log jam in the Senate on judicial nominees.
Right. Well, controversies regarding nominees is nothing new. Let's put it that way. The advice and consent power of the Senate has always been used in order to defeat the president's nominees. You can go back to Charles Rutledge, and the Teapot Dome scandals and all that stuff, and you can see the opposition. Interestingly, Rutledge was opposed by his own party, by the Federalists, rather than the opposition. But that's a different matter. You can see this is part of the constitutional politics, which is why the framers designed it that way, to have checks and balances in this process. And so that's nothing new. I think the constancy and the magnitude and the numerosity of the obstructionism was new. Because while there always, from time to time, there were instances in history where the Congress objected and nominees were defeated or withdrawn. You can think of it with Judge Bork, for example, in his nomination. You can think of it in other contexts throughout the ancient and modern history. But never was there this constant drumbeat of opposition that every nominee is suspect, and any nominee who is suspect becomes stalled, and any nominees who is not defeated any suspect nominee who's not defeated in committee is subject to filibuster. And so it's not the objection, but it's the constancy, the number, and the stridency of the objection that is the new normal, if you will. And I think that is a natural development in terms of the path of the judiciary and its role in the political process, and two, an unfortunate development for the role of judiciary in our political process. Let me explain both halves. If the judiciary remains in its proper role as the least dangerous branch, which is to have a properly constrained role of judicial review, checking legislative and executive authorities against constitutional protections, then sure, if they are operating as truly as judges, then the political process should not have very much say in that, except to confirm those who would be the best jurists, those who apply the law best. But if the judiciary is seen not as a neutral arbiter of constitutional bounds, but rather as another agent of social change or political activism, then the judiciary is in no greater moral or political authority than the legislative or executive branches. And so if the judiciary is going to act like a political institution, then sure, the branches will act as if the judiciary is a political institution and impose political standards on the third branch. And that's why the president was very, very clear in his vision that he is not there to impose any litmus tests on any political, ideological, or moral issues on the nominees. All he cares about is a person who has the right jurisprudential framework to return the judiciary to its proper role within the constitutional structure, which is as a neutral arbiter of the law, to follow the law rather than to use the law in order to impose social change. And so he wanted to return the judiciary away from the judicial activism of the last 3 or 4 decades back to the original conception of the judiciary in our constitutional structure. But because the judiciary has moved to become a political institution of sorts, the political branches were seeking to impose their own political imprint on this, and so it was a controversy that is not unexpected, certainly unfortunate, and I think is a constant reminder that we need to respect the proper role of the judiciary.
You mentioned earlier some of the special interest groups that became involved in the nominations at this point, and was that surprising to you? And can you explain a little bit about their role? Because we do, for instance, on both sides, of course, the Democrats in the Senate made the issue of the Federalist Society sort of a constant issue. But then we see a lot of other interest groups kind of driving the opposition to the nominations. Was that a surprising development to you? And can you explain a little bit about that?
No. Interest groups always have a role certainly in the confirmation process, because they're the one who comment on these things. What we wanted to be assiduous about is that no interest groups has a preferential role in the nomination process, which we thought to be a deliberative process within the executive branch, which is why we don't talk about it much. And so no interest groups had a preferential role in that process. The ABA was not given the names in advance in our nomination. The Federalist Society was not given names in advance in our deliberation. There was no consultation with any groups, ABA, Federalist Society, whomever.
as part of that process. The Judicial Selection Committee met in private among the White House and and Justice Department officials. We give our recommendation to the president in private, and he makes his decision in private. And that's how the process should proceed. Once we send it to the Senate, the chairman of the Senate Judiciary Committee made it clear that he would not clear anybody for a hearing until he gets a recommendation from the ABA. And so naturally, we would cooperate with the ABA in order to facilitate the hearing for and hopefully ultimate confirmation of our nominees. And so the ABA did have a preferential role in the confirmation process as part of the Senate Judiciary Committee's the processes. And then all the other groups, pro or con, would participate in that in order to motivate support or opposition thereto. I don't think that's surprising. Again, because if the judiciary is going to act like a political branch, then the political process will act in order to judge the judges who will become part of the judiciary. And I think that's part of the devolution, if you will, of the judiciary, originating from a misguided conception of the judicial rule. And I think that's why, and in many ways, the president was heroic in not joining the political tit for tat, but rather trying to reverse the tide by nominating people who are judicial conservatives in the sense that they want to restore the limited the role of the judiciary as a restrained judiciary, instead of nominating conservative judicial activists in order to counteract liberal judicial activists. He didn't care whether they're liberal or conservative in terms of their political philosophy. He cared whether or not they are restrained in their judicial philosophy.
Well, can you explain, maybe give us some details about who exactly was involved in the deliberative process and selecting judges and kind of how that process works? I mean, it is sort of a mystery. I mean, how many people actually get involved in trying to decide who would be qualified, and how does that suggestion end up in front of the president?
Right. It is the deliberative process, and I am, I'm loath to go into the specific details because it's not my privilege to waive; it's the president's privilege. But in general, the process is an integrated and seamless cooperation between the White House and the Department of Justice. The White House being led by the White House Counsel's Office, the Department of Justice being led by my Office of Legal Policy, with the participation, obviously, the Office of the Attorney General, and also with the participation, of course, with other interested offices in the White House. But the two core components are the White House Counsel's Office and the Office of Legal Policy. We operate fairly seamlessly. We meet once a week, and we go through both candidates for nomination and the progress of the nominees subject to confirmation. So it's both halves of the ledger. Because we had over 100 vacancies, we met every week in order to highlight candidates. And the process is that initially when we identify a seat that is vacant, we look for all qualified candidates from all quarters, be they from local practitioners, from people whom we know about, and who are within the jurisdiction, from home state senators, or from home state politicians, governors, congressmen, whoever has an interest in that and in order to bring the candidates forward. We go pretty broad in that search and try to find the right people, and then we bring about 3 or 4 or 5 candidates for a particular seat for an interview, and it's a joint interview with both White House and Department of Justice. There is fairly seamless in terms of our participation, and we bring them all in and we interview, and then throughout that process, we will identify 1 or 2 candidates who are the leading contenders. At that point, we would take it to the president for a presidential checkoff, for a briefing on where the seat is, the candidates we interviewed, and our initial recommendation. And so he says, "Great, check that person, go forth and do a full vetting." And that's our presumptive nominee. or maybe if there are two contenders, we'll have two nominees, two persons to go through that, but quite often it's just one person, and that person would go through a full-blown background check by the FBI, by the Department of Justice, a full vetting process to reconfirm our initial recommendation. And once that whole process is done, both at the White House and the Department of Justice, we would meet again on that particular seat and then review the file again and then bring that one name for final recommendation to the president for a nomination. And then the entire file is then compiled and sent over to the Senate for their confirmation purposes.
Now, would this be done for both district court nominees and appellate court nominees? And could you maybe just for the record, kind of explain the difference for the level of involvement?
Yeah, the process is the same for both district court and circuit court nominees. I think the qualification is a little bit different, and our search process is a little bit different. So how we do the vetting, how we do the interview, and how we recommend the president, that's exactly the same. District courts are a little bit different in the sense that we would give a little bit more credence to home state senators. In terms of their preferences and their knowledge of the local candidates, because it is a court of local jurisdiction. There is a localized district, either in a state or a small part of the state, and so there is more local interest. And so we listen more to what the local legislators and senators would say. And for example, we would look through the local bar association recommendations and the like. And because it's a trial court, we also put more emphasis on the ability to make decisions at the trial court level rather than long drawn out thinking and writing processes. And so those skills are a little bit different from the circuit court, which is a court of more general jurisdiction. It usually encompasses an entire region, not just one state or just a locality of a state, and it deals with issues of national importance, certainly of regional importance, but potential of national importance. And so therefore the home state senators have some say, but not as much say as if it were a district court nominee. And also because it is a court of appeals, we look for not necessarily, the trial court experience is not as important to us as the intellectual framework that the person brings to the job. It's not quick decision making, it is deep thinking and the quality logical reasoning and good judicial opinion writing. That is critical parts of that job. And so, but the process is essentially the same, even if the qualifications are different.
So you raise the issue of influence of senators, and a lot of the criticism around this time was that President Bush and the administration actually did much less consulting with home state senators. There's criticism that much of the process of selection was private, and they kind of wanted to know more about the deliberative process. And particularly compared to the previous administration. Can you explain a little bit about that criticism? I mean, is it valid? Or why exactly did the administration decide to be so private about the deliberative process? And one of the criticisms is, of course, the decision to end the American Bar Association's vetting before it actually went to the Senate.
Right. Well, look at the American Bar Association had a preferential role in prior administrations. We're not going to give that preferential role to anybody, and that's a presidential decision. I think it was the right decision, and people at the ABA may not like it. I'm a member of the ABA. I think it's fine because I don't think the ABA should have a preferential role in the executive deliberation. Any more so than American Medical Association on healthcare or anything else. And so the president made that decision. I think it's beyond reproach and beyond debate. The question as to whether we consult with the senators, home state senators, is an easy one. Of course, we consult with them, because without their consultation, we wouldn't ease the second half of the process, which is the confirmation process. Just because we consult with them, and we consult with them, immeasurably. And we know that there was criticism of this, so we were deliberate about it. There are whole logs for every nominee in the file. The first page is consultation log. Who talked to whom to where, and there's checklists of every single home state senators that we have to talk to, legislators and the like, and how many times and what date, so that nobody can ever dispute the record of consultation. Consultation doesn't mean acquiescence. Consultation doesn't mean a veto. And maybe that's where the criticism is just because the president consults doesn't mean that he will lay down and accept a veto, or just because he consults doesn't mean that he will take take it or leave it recommendation, because at the end of the day the nomination is his to make. Now, some home state senators are more influential than others, some are more forceful than others, and that's the normal politics of consultation. And so, there's no question that we consult, and we consult very widely and very broadly. Some people may not like the answer, the ultimate decision, and that's their prerogative not to confirm people in the later stage of the process. But it is also the president's prerogative to make his own decision as to who he nominates.
Well, looking at the first 2 years of these nominations, and President, let's just say that there was a record number of people who actually confirmed. I mean, it's very successful on one level of getting people onto the bench, but these few real high-profile nominees, which many were filibustered, sort of created this aura of a logjam, of a problem with the confirmation process. Can you explain the administration's reaction to that?
Right.
And what were some of the things that may have been discussed in trying to break the logjam, trying to actually get a vote on some of these nominees?
Right. So there's no question that when we came into office, that there was a very significant, even if not record numbers of vacancies. And we rightly characterized it, and the president rightly characterized it as a judiciary crisis, because we had close to, I think it was over 15% of vacancy. And out of a judiciary of 900 judges, that's a significant workload to be putting on to the active judges in the judiciary. And so we made it a priority. There's no question about that. And because we made it a priority, we nominated more judges in the first 2 years than ever in history. Indeed, at 10 times the rate of historical average for the first 2 years. And out of that, we confirmed 100 judges, almost exactly in the first 2 years, from May to May. It's 100 and 101 judges. That's also a record number of confirmation. But there were also a record number of judges who were not acted upon, or judges who were voted down in committee, or judges who were held on the floor, filibuster in some cases. And so just by the sheer size of numbers, we were very successful in terms of nomination and therefore confirmations. But the Senate was also very successful in obstructing some of the nominees, both in terms of numbers and in terms of profile. And you're right that caused significant frustration. If a guy like Miguel Estrada, who has a personal story second to none, and whose qualifications will take a backseat to no one, is obstructed, it bodes very ill for our constitutional system of an independent judiciary. And so the president was determined to find a resolution to this. And so he made a very sensible proposal. Hey, give a nominee a hearing within 60 days. Give him a vote on the floor within 180 days of nomination. Doesn't mean that you have to vote him for him in committee. It doesn't mean that you have to vote for him on the floor. It doesn't mean you have to take away the power of filibuster. Just set markers down so that everything is done in the open, so that there's no private holds, so there's no unfairness to the family, so there's no you still don't take away the Senate prerogative of filibuster. That's a very modest proposal, and it is proposed so that it is in effect, regardless whoever's in power, even if it's a Democratic president in power, we would hold to that. Even if it's a Republican Senate in power, we would hold to that. And indeed, he made it so that it would not apply to him. It would go one cycle out, so that there's no whiff of the self-dealing in this process. And I thought it was a very modest proposal. It was very sensible. It was one that does not offend Senate prerogative. It does not aggrandize executive authority. All that it does, it ensures the nominees have their day in the hearing and an up or down vote on the floor. And that went nowhere. The Senate didn't like it. And I think in many ways, the senators would prefer the threat of a nuclear option, that is breaking the Senate privilege of filibuster, than some sort of structural resolution to this impasse.
Can you tell us, with all of these things in mind, particularly the idea of a filibuster, how much discussion during those first 2 years was actually put into the possibility of a Supreme Court vacancy? Is that something that an administration prepares for, that far in advance? I mean,
Absolutely.
how exactly did that work?
We never anticipate a vacancy, because that's unilateral on the justice's part, and
Right.
it is by tradition not done in consultation with any member of the executive branch, properly so. It's just a notification and off the races. And so we never anticipate anything, but we're preparing for everything, obviously, because from the time of a notification to the time of a nomination by the president, it's a fairly short cycle. It depends on what the justice decides to do. Because the justice, if she says, I'm resigning effective immediately, then the political pressure is fairly high for us to act immediately. If the justice says, I am resigning the effective end of the term, it may give some more time. Or I'm resigning effective the confirmation of my successor. That gives you even more time. But it all depends on how much time the justice would want to give the president, and the justices all differ in their styles when they choose to resign. Death and disability is another possibility. So we're always preparing. And so but it is obviously it's a preparatory process. It is not a selection process. And so we're just in many ways we just make sure that we have all of our work done. Should the call is made that the president would like to look at recommendations. And so all that staff work proceeds in any administration. So everybody has got the prep work well in advance.
What kind of work would you put together? And I guess I'm thinking that with a lot of people arguing that Estrada was, on some type of fast track to be a Supreme Court justice, and the fact that Judge Roberts was in that first group of nominees. I mean, are you thinking at that point that one of these people are probably going to end up on the Supreme Court? And exactly, what is the thinking in those?
Well, look, the presumptive thinking has got to be that every single circuit court judge is qualified enough to be a circuit court judge. And if he or she is qualified to be a circuit court judge, he or she is qualified to be a Supreme Court justice, because they are of the same qualifications. If you're not willing to put somebody on the Supreme Court, you should not be willing to put that person on the appellate court, because it's essentially the same function, the same qualities, but just different pay grade, if you will. And that's the high standards we put our circuit court judges through, that they have to be of sufficient quality, integrity, and intellect in order to serve as a Supreme Court justice. And so by definition, that doesn't mean that every single potential potential Supreme Court nominee is a circuit court judge, right? There are other people who fall into that mix, and I can tell you that of the group of people who would make a good justice, we looked at people and we seriously considered people who are not sitting circuit court judges for the obvious reason that they had other careers. They were not interested in circuit court judgeship, and so the potential pool is broader than circuit court judges.
actually, that's a curious point because it is very rare for anyone but a circuit court judge to become a justice.
Only
now.
in recent experience.
Only in recent experience,
Yeah.
and it seems to be a real.
And the D.C. Circuit is where you want to go.
Yes, I mean, and then there is some criticism in all administrations that maybe the country isn't represented quite as well by not going out of that kind of small circle of people.
Right.
I mean, why is that?
I think there is a reticence of nominating unknowns. I think that there is rightly or wrongly, people have seen different nominations at different stages, and say that, these judicial posts are so important and the consequences are so great that we should not take a flyer on somebody who have not had the experience of making decisions under real world circumstances. And so we know nobody's going to get through the process without everybody knowing them and know how they think and all that stuff. But there is a concern that until you put in real world situations with real responsibilities, with real consequences, with real pressure, that you would never know how a person would make decisions under those circumstances. We can always say, I think you take 100 people of whatever stripes in this town, and everybody will agree on the platonic ideal of Chief Justice Roberts of a neutral arbiter, an umpire who calls balls and strikes fairly. I don't think that a Democratic leader like Senator Schumer would differ with a Republican leader like Senator Hatch in that regard. Like, everybody agrees that's the bounds. But how big is the strike zone? How close is you can call a ball? Does 3 and 2 matter, or is it 0 and 0 matter? Those are the real marginal the questions that you really want to get at, and nobody really wants to take that risk of guessing whether this person is going to make a call differently at 3 and 2 or at 0 and 0 without actually seeing the performance. And so even with limited data sets, and so there's more reliance on actual judicial performance as a indicator of judicial philosophy.
Okay, I know we're running a little low on time, so I kind of want to wrap it up. And there's a couple of questions. You left the administration in 2003.
Yeah.
And that is right around the time that President Bush decided to renominate several of the nominees that had no action in the previous session of Congress. Maybe could you tell us about the reason that you left the administration and sort of how things were when you left?
Right.
And maybe give us a little bit of sense of what you think President Bush's judicial legacy is.
Right. I think the reason I left is very straightforward. We had come into the department with a fairly comprehensive memorandum of priorities. I talked with John Ashcroft. I talked with the chief of staff, and I talked with the White House counsel. And we kind of agree as to what the transition priorities are for the Department of Justice, what the goals what the president would like to achieve for the 4 years of his first term in office. And because of the accelerated pace of policy making and the legislative process within the first 2 years, at the end of the first 2 years, we pretty much saw all of our priorities met, and added onto that a significant effort having already been made in the war against terror, which is a completely new and overriding priority in terms of Patriot Act, the regulations, and all the other associated issues that came out with the 9/11 attacks. And so there was a sense from my personal experience that let's let another person with fresh ideas and fresh energy come in and take over the helm of policy development for the department. And also because in my personal circumstances, my leave of absence from Georgetown Law School, where I was tenured, was for 2 years. I'm sure I could have extended it, but it was a natural breaking point, and so we did not seek the extension of the leave of absence. The where we left it is fairly straightforward. There were some significant successes, in terms of confirmation. I think that Jeff Sutton, Mike McConnell, and the 100 other judges that were confirmed were a record number for the presidency. In terms of on the policy side, we had unprecedented success in counterterrorism and all the legislation that we pushed through. In judges, we were extremely successful. There were some obstacles caused by the obstruction of the Senate, and I think that Justice Priscilla Owen, Judge Pickering, had gotten voted down in committee. Miguel Estrada never had a hearing. Those are the people that we were not able to get through in the first 2 years. The president decided to renominate them for the exact same reasons why he nominated them in the first place. They are the best, most qualified people for the jobs that were vacant and were dangerously unfilled. For the judiciary, and so for each of those nominees, the Senate never formally rejected them because they never had a vote on the floor, and so until the Senate formally rejected the nomination still remains alive. And just because the Senate went out of recess and returned all nominations, simply means that we re-nominate all of them back to the Senate until the Senate states affirmatively that they do not give advice and consent to this particular nomination. That if and when they have an up or down vote on the floor and they were defeated, that's when the consideration would change. But until then, our original reasons for nominating that person remains the same.
And what do you think about maybe the state of this whole process and what the legacy of President Bush is when it comes to the judiciary?
Well, let's start at the very top. You've got John Roberts and Justice Alito at the Supreme Court. I think they will go down in history of two of the best justices in the court, rightly or wrongly, whether you agree with them or disagree with them. No doubt they bring a judicial philosophy that is restrained, that is completely consistent with the president's philosophy that the judges do not make law. They don't advocate for social change. All they do is call balls and strikes. They follow the law, they don't make it. And whether you agree with them, whether you disagree with the result in a particular case, nobody can question the judicial integrity of John Roberts and Justice Alito in that regard. And I think that is an unalloyed success in terms of the criteria that the president put to the task, and the success he is in carrying out that criteria in his judicial nominees. And I think from that top, you go all the way down to the judiciary, and maybe not to a person, but largely the entire core of Bush 43 nominees and judges have that same imprint. That whether you agree or disagree with them in particular cases, whether you agree or disagree with with how they judge particular facts, they all have this vision that they are there as neutral arbiters. They are there to follow the law and not to initiate social change or not to make the law. And that bespeaks a correctness of criteria and a consistency of carrying through that criteria through the selection process. And that, I think, is the greatest legacy of the Bush judicial presidency.
Okay, thank you, Viet. Thank you very much.
Thank you, Aaron.